Good evening. Thanks for coming. It's nice to be here, as Jensen said, to celebrate for a change. And also nice to be back. I don't know if there's anybody here from Northeastern, but thank you for hosting us. I went here back in the 70s, and it's a bigger, brighter, more impressive place than it was back in the day when we were just reopening. Also, thanks to Tom for coming up by train from New York. We appreciate that. Particularly thanks to Maurice for doing all the hard work setting this up. We appreciate all the groundwork. And Sarah for joining us. Sarah's doing a lot of good work in Boston, has been doing for years. Glad's work on Goodrich back in the early 2000s, which resulted in the Supreme Judicial Court's decision in 2003, is really what cracked the door open for the steps that we've succeeded at right now. So I've always been very grateful to Glad. From 1952 to 1990, the Immigration and Nationality Act excluded all gay foreign nationals from the United States as persons of psychopathic personality. Did people even know that? Barney Frank and Ted Kennedy worked for almost 10 years on the subcommittees in the Senate and the House to eliminate what was called the gay exclusion. But that gay exclusion was upheld by the U.S. Supreme Court in the late 60s, probably the most liberal Supreme Court we've ever had. So we really have gone through some incredible changes. Nobody who was gay and who was known to be gay could get citizenship because we were determined to be persons of bad moral character because of the fact we were gay. Then later on, the Rhode Island Federal District Court said that it wasn't just that you are gay, it is that you are practicing gay. We had to fight through that to say that being gay or practicing gay isn't the ground to say that we're persons of bad moral character. And then we had DOMA, and then we also had the HIV exclusion that was thrown in during the amnesty in the 80s, and was the only way to get around it was to have an anchor relative of a parent, spouse, or child who was a U.S. citizen or permanent resident. And the Congress people who passed that knew that most people who had HIV then were gay men, and that we didn't have spouses then, and most of us didn't have children, and most of us wouldn't have, if we were foreign nationals, wouldn't have our parents here with us. So there was no waiver for the HIV exclusion. And that was removed only 2 years ago, about 2.5 years ago. So what Jansen said is true. There's been enormous changes in a relatively short period of time, and all in the right direction, I think. What I want to do is just sort of explain what the lawful permanent resident categories are, go through these very quickly, then focus on the family-based area, and then within that focus on marriage. But just so you sort of get a context of it. Congress sets up in the law who can become a permanent resident, and it's controlled rather strictly. There are 800,000 or 900,000 people a year who become residents, one of the most liberal numbers in the world for people becoming residents of any country, and yet at the same time fairly restrictive. The biggest category is the family-based one, and the biggest in that probably is children, just because of the numbers of children from couples. But the thing that opens the door for most people is marriage, and we were excluded from that. There's also a diversity lottery, an investment program, asylum and refugee. If you are an asylee now or applying for asylum and you are married, your spouse can also get asylum through you derivatively. That because the marriage is recognized, you'll also get that. If you have already been granted asylum and you can act within a certain number of months after you're granted and marry someone, you can then include them after the fact and get protection for your spouse now. So if anybody is here who is applying for asylum or has applied for it and been granted it, you should consult someone to discuss if you're in a relationship, whether or not you do want to get married, and then what protection that would give your spouse if your spouse is also a foreign national. Cancellation of removal. If you're in front of a deportation judge and the judge is going to order you removed, or what we used to call deported, you can ask the judge to cancel it, but you have to show extreme and extraordinarily unusual hardship to certain relatives, one of which is a spouse. We never had that before, now we do. So if you're married to a U.S. citizen or a permanent resident spouse, and you are in proceedings in front of a judge, you may be able to defend yourself from deportation, or potentially now even reopen old cases where that defense was not previously available. So there's a whole a number of different ways of gaining permanent residence, but again, the family-based category is the one that's the most common. There's only two sets of people that can sponsor someone on the family side for residence: a U.S. citizen or someone who's already a permanent resident themselves. The U.S. citizen can sponsor a parent, spouse, a child under 21, and we'll describe those three as immediate relatives, or sons and daughters 21 over who are married or unmarried, or brothers or sisters. And these are available only if you're a U.S. citizen sponsoring. If you are a U.S. citizen and you want to sponsor your parent, you have to be 21. So you can't just have a child here and then have who is a citizen by birth sponsor the parent. You have to have the child become an adult and then sponsor the parent. Certain relatives are, my graphic setup is a little strange here, but anyways, certain relatives who are sponsored by U.S. citizens are called immediate relatives, and that's the parent, spouse, or unmarried minor child of a U.S. citizen. And this category is huge. This is the one that probably many people here would fit into, or perhaps many of your friends. There's no annual quota, and there are very, very severe quotas. If I file for my brother in Italy, when I file a petition for him, I put him in a line that's 10 to 12 years long. So that quota, it can be overwhelming. We're going to see a graphic of how bad things are backed up in some of the family categories. The spouse of a U.S. citizen has no quota to face. They're called immediate relatives, meaning the numbers are immediately available. And that's obviously huge. Also, the spouse of a U.S. citizen can apply for permanent residence even if they've overstayed their time in the United States. So if I came on a student visa and stayed here longer than I should, I tried to get a job to sponsor me for an H-1B, I couldn't get it, and things just fell apart. I can still get permanent residence through my spouse if he's a U.S. citizen, because that period of being out of status is forgiven, as is work without authority. So if I also went on to support myself and didn't get the permission of the government, that fact can usually block people from getting residence while they're in the U.S., but not the spouse of a U.S. citizen. So this category is huge. I mean, this is what opens the door for most people. The other relatives who are, besides the immediate relatives, are in that preference system of categories where you try to get higher up in the preferences to have faster access to numbers, but there are strictly held quotas, and they're in a thing called the visa bulletin, which I'll show you. If you're a permanent resident yourself and you want to sponsor your foreign national spouse, you can do that, or an unmarried son or daughter. But if you are a permanent resident, you cannot sponsor a married son or daughter or a brother or sister. So those categories are different. And generally, usually there has been a backlog in the quotas for the spouses of residents and the unmarried sons and daughters of residents. So no other relatives can be sponsored. And I always, whenever I had to give a talk, like at the colleges and universities around here, in this list of relatives that cannot be sponsored, I always had to say same-sex couples. That's gone. It's just fabulous. Adopted children can be sponsored, but the adoption has to take place before they turn 16. So if you're thinking of adopting internationally, you need to make sure that the adoption is effected before the child turns 16. Otherwise, the relationship for other purposes may be recognized, but not for immigration purposes. Stepchildren and step-parents can sponsor one another, but only if the step relationship was created before they turned 18. And there are several, we're facing a possibility of comprehensive immigration reform in Congress, which is badly needed. One of the bad things is they're talking about eliminating the brother-sister category, the sibling category altogether. So that is problematic. Now, that visa bulletin I talked about has several different pages. Thank you very much. Has several different pages, and one of the pages is this chart that shows in the family-based categories where they are right now in the waiting line. If I am a permanent resident and I marry you, when I marry you, I can file a petition to sponsor you. That gets you in line and gives you a date in line. So today is what, July 24th? July 24th, 2013. So if I file for you today, your date in line is July 24th, 2013, and you cannot apply for permanent residence until that date, that's called your priority date, pops up on this chart. And the first preference category is unmarried sons and daughters of citizens. What happened just effective August 1st is huge, though. F2A is the spouse of a permanent resident. And for the first time in, it must be 10 or 12 years, maybe longer, it's become C, which means current, which means there are numbers immediately available. That hasn't been happened, I think, at least for 10 years or maybe 15. So as of August 1st, if I filed for you because I was a permanent resident, you're eligible for a number immediately. They anticipate, the Department of State produces this. If you go to the Department of State's website and punch in Visa Bulletin, this will pop up, and it comes up every month. The Department of State is advising they anticipate numbers will remain current for 7 months. That doesn't always last, and I'm sure they're trying to make a good faith estimate, but until it does last, it means that the spouse of a permanent resident, with some serious exceptions, may be eligible to apply for permanent residence in the United States, not have to leave because a number would be immediately available. The other categories, you can see F4 is backed up from 2001. That's the brother or sister of a US citizen. So you can study that. There's a series of materials with the Visa Bulletin that it fills in all the blanks. That's right. If the spouse was not, if the number was not available, which they hadn't been until, or wouldn't be until this August, then I could file a petition for you, but in most cases you would end up having to apply abroad. You might not have to leave, they don't go after everybody, and you might be able to maintain legal status in the meantime so that there's absolutely no reason to leave. But if I filed for you and there was a long waiting line, you aren't going to get the benefit until you're at the top of that line. So there's two ways of going for permanent residence. One is adjustment of status, that's an application inside the United States, and the other one is consular processing through an American consulate. If you can do it here, you're much more protected than if you do it outside the US. Obviously, if you're outside and they say there's some problem, you're going to stay outside while that problem is resolved, and if it's a significant problem, it may never get resolved and you'll be there, not here. Excuse me. Another thing with adjustment of status is that you have appeal rights at many different levels. The citizen spouse who sponsors has right to appeal if there's an adverse decision on the sponsoring petition, but you also have a right to have an immigration officer review the decision, a judge review the decision, Board of Immigration Appeals, and then the federal court. So if you can stay here, if you're eligible to file by way of adjustment, there are many more protection than rights. But some people cannot, and if they have to go outside for consular processing, you need to consult with an attorney as early as possible and very carefully to determine what's ahead for you, because there are serious penalties when you go out to try to pick up that visa if you've been here in unlawful presence for more than 6 months, and even worse if you've been here for more than a year. So if I file a petition for you as my unmarried son or daughter, and you think 6 years later you can go pick the visa up and come back in no big deal, that's not true. It's complicated. There are a number of additional steps you have to go through to try to get back, and you ought to know about them in advance and prepare for them.